My name is Yiğit Yenetişme with my colleague Sasha Daol. Today we are going to make a Pecha presentation on the issue of the digital theft of cryptocurrencies and their legal classification with respect to the comparative approach.
Comparative-wise, we define certain terms which are imminent when talking about cryptocurrencies. We focused on the possible criminal liability in digital thefts. We took a functional approach and systematic approach. In the following, we present our results. One of the reasons why cryptocurrencies are popular is that transaction fees are almost non-existent. The price is so low that it's much cheaper than the transaction fees of regular transactions. Due to the organization of the network as a peer-to-peer network, there is no need for a third party which controls and validates the transaction. The pseudonymity within the network allows for a worldwide cryptocurrency exchange without the fear of a state tracking them back to someone, as long as the identity behind the public key is unknown.
In both systems, paper money accepted as a movable property, but the cryptocurrencies are not a movable property. Banknotes are printed by central banks according to certain law, but cryptocurrencies is not tied to any authority. Therefore, it is not possible to place cryptocurrencies into paper money category. Electronic money issued by certain companies authorized by central bank. With the interpretation of the Turkish Court of Cassation, electronic money accepted as a movable property, and it is possible to commit theft crime on it by using electronic information system. But in a both law system, we cannot place the cryptocurrencies into the electronic money category. Representative money is just a reflection of the paper money in a digital account. With the interpretation of the Turkish Court of Cassation, it is accepted as a movable property, and it is possible to commit theft crime on the representative money by using the electronic information system. But in the both law system, we cannot place the cryptocurrencies into the representative money category.
Cryptocurrencies are a digital representation of value and are not created by a bank or other institution. Therefore, cryptocurrencies are to be categorized as virtual currencies. Cryptocurrencies are listed as units of accounts by the BaFin in the leaflet about the finance instruments of the paragraph 1 subsection 11 KWG. Cryptocurrencies are a digital representation of value which is not given out by a central bank or public authority and is not a legal currency. With that, it qualifies as a crypto value.
As you can see on the screen, it is not possible to place the cryptocurrencies into any of them in Turkish law system. It just accepts as an ordinary data without looking at its economic value. But in a German law system, there are 4 options for cryptocurrencies.
Possibly relevant are the paragraphs 202a subsection 1, 303a subsection 1, 263a subsection 1 variation 3, and the paragraph 242 subsection 1 of the German Strafgesetzbuch. In case of a digital theft, only the paragraph 202a subsection 1 StGB is relevant.
In here, Article 141 is the basic version of the theft crime. Article 142 subarticle 2 paragraph E is aggravated circumstances of the theft crime, which is by committing with usage of the electronic information system. In Turkish law, the criminal responsibility will arise in terms of the theft crime if the object of the crime is a movable property. It is not possible committing theft crime on the cryptocurrencies. In Turkish law, cryptocurrencies accept as an ordinary data. So the person who accesses the crypto market account or blockchain network of someone, they shall be punished for accessing a data system. If that person not only access but also transfer data to their account and gain benefits, they shall be punished for aggravated circumstances of accessing and altering data system. In a summary, according to the Turkish and the German law system, the person who steals the cryptocurrencies shall be punished for the accessing a data system instead of the theft. They are both not accept the cryptocurrencies as a money. They are both punishing the person who is accessing a data system in order to accrete public and private key for the crime. It is not important how you access the cryptocurrency market account or network in Turkish law. Only important thing is that access should be carried out without the consent of the account's owner. But in a German law, if you access directly to the network with public and the private key, it is not possible to commit the crime of accessing a data processing system. In Turkish law, the person who accesses the crypto account and transfers the cryptocurrencies to his or her account and gains some benefits shall be punished for the aggravated circumstances of accessing a data system and altering data system. This aggravated circumstances does not exist in a German law.
As possible reasons for the differences, there are the systematic differences. The German law separates most laws after their legal interests, while Turkish law doesn't have the need for that. In Germany, unlike in Turkey, the numerus clausus disqualifies the keys as a property and by that any ownership.